My name is David Holterman. I'm the General Counsel of the Lawyers Trust Fund of Illinois. The Lawyers Trust Fund is the administrator of the IOLTA program here in the state of Illinois. The title of this program, Trust Account Issues and Related Succession Planning, includes two concepts that you may not associate with one another. For lawyers who are in small firm or solo practice settings, however, they are both connected and very relevant concepts. For example, there are questions that may occur to lawyers in these practice settings about what happens to a client trust account if a lawyer becomes incapacitated. What is the impact on a lawyer's estate if she unexpectedly passes away while holding client funds? And what if there are funds in a client trust account that cannot be traced to a particular client or a particular matter? Properly handling client funds is an important professional duty of lawyers, and client trust accounting should be part of any succession planning, especially for lawyers who are nearing retirement age, scaling back practice, or making other plans to transition away from the active practice of law. While this segment is appropriate for lawyers at any stage in their career, it is particularly relevant for lawyers in solo or small firm practice settings, and it is also relevant for lawyers who are experienced. There are a few data points in the most recent ARDC report covering the year 2015. One data point is that more than 38% of Illinois lawyers, that's more than 26,000 lawyers in total, are solo practitioners or work in law firms of 10 or fewer lawyers. So these are lawyers who are working in either solo settings or small firms. Unfortunately, another data point is that experience is not a shield to getting in trouble with the ARDC. More than 1/3 of the investigations docketed by the ARDC in 2015 concerned lawyers who have been in practice for 30 years or more. Now, the objectives of today's segment are to take a look at some of the important reasons to think about making a plan for your succession and to include trust accounting in that plan. During this segment, we'll also take a look at the requirements of Rule 1.15, the Safekeeping of Property Rule, and to talk about or identify ways to develop and implement components of a plan specifically regarding your client trust accounts. Those components include record keeping and designating an agent or successor, winding down your client trust account, bank requirements for closing a client trust account, how to deal with remaining balances in the client trust account, and then I will conclude by providing you with some additional resources regarding IOLTA and unidentified funds. In looking at reasons to plan for regarding your trust accounts, it's important to keep in mind that anyone in practice should expect the unexpected. Death and incapacity are both things that can happen without any warning, and are realities that practitioners need to be aware of, particularly if practitioners are in solo settings or small firms where coverage or backup may not be readily at hand. The primary reason for planning is to prevent client harm. Under the rules of professional conduct, there's a duty of diligence which is addressed in Rule of Professional Conduct 1.3, and the commentary to that rule speaks specifically about the need for succession planning. The comment 5 includes the statement that to prevent the neglect of client matters, the duty of diligence may require that each sole practitioner prepare a plan that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. Another reason for planning is that it is required by the Safekeeping of Property Rule, which is Rule of Professional Conduct 1.15. Under paragraph A, section 8 of that rule, a lawyer is required to make appropriate arrangements for the maintenance of the records in the event of the closing, sale, dissolution, or merger of a law practice. Another practical reason to include trust accounting in any succession planning or transition planning regarding your practice is to avoid any impact on your estate. It is also to avoid hindering the sale of your practice under the rules of professional conduct and Rule 1.17 specifically. Now, before we get into the components of planning and some of the details of how to implement them, it's worthwhile to review some of the basic regulatory backdrop involving trust accounting and their requirements. As you are aware, safekeeping of property is a primary duty of professional conduct for lawyers. Lawyers must hold client and third-party funds in trust. Those funds cannot be commingled with the lawyer's own funds. And the reason for this is that lawyers have a fiduciary duty to safeguard and segregate funds belonging to clients. The goal, the underlying principle, the underlying reason for that duty is to eliminate the loss of funds and also to eliminate the risk of loss of those funds. As a result, the rule functions, the safekeeping of property rule functions to instruct lawyers to avoid commingling or mixing their own funds with client funds and to avoid situations where client funds might be converted by the lawyer. This is important to maintaining public trust in the profession. And the principles regarding safekeeping of property are codified in Rule 1.15 and its predecessors. Taking a look in detail at Rule 1.15, the basic safekeeping requirements are included in paragraph A, where it states that any funds of a client or a third person must be deposited in a client trust account, either an IOLTA account or a non-IOLTA client trust account. And those funds must be held separate and identifiable. They must be held in an account that is interest-bearing at an eligible financial institution. Paragraphs F and G of Rule 1.15 address IOLTA and address when client funds should be deposited in an IOLTA account. Now, there have been some recent updates to Rule 1.15 that are important to be aware of. In 2011, there were several sections that were amended and, in fact, added to Rule 1.15. First of all, paragraph A and paragraph F were both amended to clarify that there are only two types of client trust accounts allowable under the rule. IOLTA accounts and, as I mentioned earlier, non-IOLTA client trust accounts. And again, both types of accounts must comply with the basic requirement that they are held in interest-bearing accounts at eligible financial institutions. Another important addition to the rule in 2011 you can find in paragraph A and in paragraph A 1 through 8, which is the addition of some record-keeping requirements, which enumerate the types and nature of records that should be maintained by lawyers in holding client trust accounts. Another important addition to the rule was paragraph H, which was added in 2011, which concerns overdraft notification. Overdraft notification is essentially states that a lawyer must hold a client trust account only at a bank that has agreed to provide notification to the ARDC in the event that the client trust account has been overdrawn. That's one component of this eligible financial institution language that you would find in the rule. This is an important safeguard that the ARDC implemented and is seeking to follow up on with regards to the safekeeping of property rule. In the past 5 years, more than 1,900 lawyers have been investigated by the ARDC as a result of overdraft reports generated pursuant to paragraph H of the rule. Finally, in 2011, the rule was amended to address how, in paragraph G, language was added to guide lawyers in making the determination about whether client trust funds should be held in an IOLTA account or a separate client trust account. One component of that is the addition of a reasonable judgment standard regarding that decision by lawyers. Another significant amendment to the rule was made in 2015, and that concerns unidentified funds. And you can find that amendment in the new paragraph I in Rule 1.15. I will go into the details of that particular amendment in a few minutes, because it is relevant to the issue of succession planning in handling your client trust account in a practice transition situation. I'm going to turn now to some of the basic principles and concepts related to planning. Step one concerns things that you can do now while you're currently in practice to help ensure that your house is in order. These are things that you can do whether you plan to retire in 6 months or in 5 years. The first idea is to simply inventory the property that you hold in trust. Are you aware of what your client trust accounts, where you have client trust accounts, which financial institutions they are at? Are you aware of what is in those client trust accounts? Do you hold other property, tangible property that belongs to the client, perhaps in a safe deposit box or elsewhere? It's a fairly simple task, but is a basic piece of work that you can do to be prepared. Another idea is to get your client trust accounts in order. And that means digging into each account and doing the reconciliation and checking that is required by Rule 1.15, and that has been required by Rule 1.15a since 2011. Specifically, Paragraph A requires at least quarterly reconciliation of account records, and that means corresponding the information that you have from your bank with a particular client and your client records to ensure that you can identify which deposits in that client trust account belong to which client or third party and in what amount. Another component of Rule 1.15a, which was also added in 2011, is that you should also maintain a client ledger. And a client ledger essentially offers a breakdown of what funds are owned or belong to a particular client and reflects activity on that client's account. For example, withdrawals to pay for court costs or for earned fees, as well as deposits, for example, in the case of a settlement or payment of other sums pursuant to the matter in question. The importance of a client ledger is that if they are properly maintained and kept up to date, they will enable a third party to understand what is going on regarding that particular client and to understand more globally what is going on with the client trust account. Another important thing to keep in mind, especially if this process of periodic reconciliation and maintaining client ledgers is something that is either very cumbersome to do within the time constraints of your practice or something that you're simply not comfortable doing, is consider making the decision to hire an accountant or a bookkeeper on a temporary or part-time basis to provide this type of service for you. It is certainly one effective way to ensure that you have your client trust accounts in order and are in compliance with these newer requirements of Rule 1.15. Some additional steps in planning are covered in this slide, and these involve, after you've taken inventory, after you understand what is in your client trust account, these involve looking outward and planning for the next step. If you're a solo practitioner or in a setting where you may be, let's say you're of counsel at a law firm and you don't necessarily have coverage or someone else within that firm setting who will be able to take your cases up for you, it is important to designate an agent or a successor. This is not just a best practice, it is something that is discussed in the Rules of Professional Conduct. I mentioned earlier Rule of Professional Conduct 1.3 and this duty of diligence and the concept that a sole practitioner should consider designating a successor or somebody who can take responsibility for the case later on in the event of the lawyer's incapacity or death. That has direct relevance to this concept of designating an agent or successor. The commentary to Rule 1.3 says that this person should be a competent lawyer. Regarding client trust accounts, it's important to add this person as a signer on those trust accounts. Adding as a signer is not it's not a legal process per se. It's more of an administrative or clerical matter to take up with your bank. Most banks will need you to provide and will need the successor or agent to provide photo ID as well as a social security number to add somebody as the signer. The bank may also require new resolutions from the practice stating that this new person is to be added as an authorized signer on the account. Some of the details of this will vary from bank to bank, and it's important to talk to your bank about the best way to handle it. Another important step is to create and then leave written instructions somewhere where they can be found within your office. You can provide written instructions directly to the successor or to the agent. You can leave instructions with a secretary or an assistant within your practice. These written instructions should identify all the client trust accounts that you maintain, and should include the account number and relevant information. And they should include the location of the account records within your office as well. It is also important to address in any written plans you have more generally regarding your succession or retirement. It's important to include trust accounts and any specific instructions regarding your client trust accounts in those instructions. Now, at the Lawyers Trust Fund, we're often contacted both by banks and by lawyers about what to do if there are plans to close a client trust account. Let's say that funds are that a practice is going to be wound down, and the lawyer intends to step away. The first important step, which we have already been through, is reconciling the account ledgers. So it is at that juncture that the lawyer, possibly with the assistance of other people within the practice, as well as an outside person such as an accountant or bookkeeper, should go through the records, go through the ledger for each client, and reconcile activity on each client account with the records supplied by the bank. So deposit and withdrawal records regarding the account. When client funds are going to be transferred to another lawyer, let's say a case is moving on to another lawyer, they must be paid to that lawyer in a check that is jointly payable to both the client and the new lawyer. Any funds that will not be transferred on to another lawyer in the event of a new case or a continuing case should be dispersed to their owner. It could be a client, it could be a lien holder, or another third party. When these funds are dispersed to clients or lien holders or third parties, it is important to document that the disbursement is being made. It's also important to communicate to each client and lien holder that you are dispersing the money to them. It's important to inform the client if you're withdrawing an earned fee or expending the funds for any other purpose, such as paying an expert witness or covering some other cost related to a matter. If funds are being returned to the client, your letter, your documentation should explain the circumstances of that refund or returning of funds to the client. The same principle applies to paying lien holders. Document for your own records that the payment is being made, and also communicate in writing to the lien holder the purpose for which the payment is being made. It is also time when you're going through this process of reconciliation to withdraw any earned fees that haven't been previously withdrawn. Again, this is an important matter to document for your own records and then maintain. For pending matters, it is important to plan for the settlement of the account as fees are paid. Now, Rule 5.4 allows for payment over time to a lawyer's estate in the event that a matter is settled after a lawyer has become deceased. Another source of money that is often in client trust accounts is seed money. That's money deposited by the lawyer to meet the minimum balance requirements under Rule 1.15b. That's a permissible type of deposit of the lawyer's own funds into a client trust account and an IALTA account. As you're beginning the process of closing down that client trust account, it is appropriate where you have adequate documentation and recollection of that deposit to then withdraw those funds and reclaim them. Banks will also have requirements before closing your client trust accounts. You want to make sure before, as you begin the process of withdrawing your earned fees, as well as making payments to clients, former clients, and lien holders, you need to make sure that you have sufficient funds in the account to cover any outstanding checks that have yet to clear. Once that process has happened, once those checks have cleared, an authorized signer on the account can simply go to the bank and ask that it be closed. If in situations where a lawyer has passed away and that lawyer was the only signer on the account, this will be a more complicated process. Many banks will require a letter of office that has been issued by the probate court after a probate estate has been opened. And there are three basic versions of letters that we are familiar with in these situations. Letters of office are issued to an appointed executor when there is an executor designated under a will. There are letters of administration in cases where somebody has passed away intestate. And then letters of administration with a will annexed are issued to an administrator when a person or entity appointed by the court as a representative was not named as the executor in the will. Any of these basic types of letters of office or letters of administration should be sufficient for the bank to act on the instructions to close the trust account. Now, there are situations where there are remaining balances in a client trust account that cannot be identified or returned even after the process of reconciliation and payment of amounts owing to clients and third parties and so on. These remaining balances fall into two categories. One category consists of unclaimed funds, where the owner of the funds is known but cannot be located or is otherwise unresponsive. For example, a lawyer may know that a former client is owed $1,500 from the client trust account. The ledgers clearly state that the client owns that money and the money should be returned to that client. But the client has moved and has left no forwarding address, and the lawyer's efforts to contact that client have not been successful. In these cases, the lawyer should follow the disposition of unclaimed property statute here in Illinois. That statute is 765 ILCS section 1025, and it concerns funds, again, where the owner is known but cannot be located or is unresponsive. These types of funds are considered to be or presumed to be unclaimed after 5 years, and they must be remitted to the state treasurer through the state treasurer's iCash program. You can find information about that at icash.illinois.gov. The second category of funds, remaining balances in a client trust account, consists of unidentified funds. And unidentified funds are the subject of Rule 1.15 paragraph I, which is the new amendment in 2015, which took effect on July 1st of 2015. And these unidentified funds are defined as amounts accumulated that cannot be documented as belonging to a client, a third person, or the lawyer or law firm. And under the rule, under this new paragraph I, lawyers are required to try to identify and then return those funds. And after 12 months of efforts to do so, then a lawyer must make a determination about whether additional efforts will succeed. If a lawyer makes the determination that those efforts will not succeed, the rule in paragraph I instructs those lawyers to return, to remit unidentified funds to the lawyer's trust fund. So the basic principles are that a lawyer should make periodic efforts to return those funds over a 12-month period, and after 12 months remit them to the lawyer's trust fund. Now, important questions and the basic action required by paragraph I is left to the reasonable judgment of the lawyer. So when are funds unidentified and when have reasonable efforts essentially been exhausted are both left to a lawyer to determine. It is also important to note that there's a refund provision in Rule 1.15I, which states that if a lawyer remits funds as unidentified and then later discovers that who those funds belong to, or let's say a client or a lien holder steps forward and claims those funds, the lawyer can make a claim to the lawyer's trust fund for the return of those funds, and after a proper verification, we will return the remittance to the lawyer so that the client or third party may be made whole. There are some important instructions regarding the remittance of unidentified funds, and the key one is that there is a reporting form that is required to accompany the remittance. This form is available on the website of the Lawyers Trust Fund at www.ltf.org. It also has been provided in the materials. It's a two-page form. One side has important instructions to follow in making remittances, and then the other asks for basic information and the lawyer's verification about the remittance. It is important to send that form and the remittance to the exact address that has been stated on the form, and to follow the other instructions on the form. Before moving on from this topic of unidentified funds, I want to repeat the distinction between unidentified and unclaimed funds. Again, if the owner of the funds is known to the lawyer, but the owner cannot be located or is otherwise unresponsive, those funds are unclaimed, and after 5 years should be remitted under the statutory requirements to the Illinois Treasurer as unclaimed funds. Only when funds cannot be traced or identified as belonging to a particular person, client, third party, only those types of funds should be remitted to the lawyer's trust fund after the appropriate diligent efforts to identify the funds and return them. And again, I'm going to just briefly review the basics of closing a client trust account after you have finished administering and dispersing any remaining balances on the account. Once again, don't forget to ensure that sufficient funds are available to cover any outstanding checks that have been written on the account. And it's important to build in some time between the closure of your practice and your decision or your plan to close your account to accommodate any outstanding checks. And then significantly, an authorized signer on your account can close that account. And if it is an estate, the bank will require letters of office or administration in the event the lawyer has passed away. If the client trust account is an IOLTA account, we also ask that either the lawyer who's closing the account or the administrator submit an account closing form to the lawyer's trust fund. Again, that is a form that is available on ltf.org. It's also available in the materials. And that is important to ensuring that LTF has noticed that the client trust account, the IOLTA account, is no longer active. In closing, these next few slides in the materials show a number of important resources to keep in mind. The source of guidance and the first place to consult regarding questions related to client trust accounts are the rules of professional conduct, and specifically Rule 1.15, the Safekeeping of Property Rule. There's some additional relevant information in Rule 756, regarding the reporting of client trust accounts when lawyers make their annual attorney registration. The ARDC on its website has a number of very helpful resources. The most significant of those is the ARDC's Client Trust Account Handbook. There are also some very helpful articles about closing a law practice and also for seeking assistance through the ARDC's Ethics Inquiry Program. At the Lawyers Trust Fund, at our own website, we have links to a number of important or helpful resources, including Rule 1.15. There's also written instruction and explanation about the IALTA program, participating in IALTA, and as I said, the IALTA account closing form, as well as information about remitting unidentified funds and in using the unidentified funds reporting form. If you need assistance, we are always available at LTF to take your call. My name, as well as the bank, as well as the name of our Director of Banking, Terry Smith, are on this slide, and feel free to contact us with any question. I hope that this session has been helpful for you understanding and thinking ahead about some of the issues and imperatives related to client trust accounting in planning ahead for the time where you may be leaving practice or unable to tend to your practice due to an unexpected event. Thank you for your attention, and please again reach out to us at LTF if you have any questions about your client trust account. Thank you.